Hello, thank you for watching the Mitchell Law Tea Break. I'm Catherine Mitchell and this is Joanne Sefton. Today we're going to be talking about recruitment, and like me you may occasionally have heard HR described as the hiring and firing department. Probably not by someone known for their dazzling wit and knack with wordplay, but we can't have everything. Anyway, as employment lawyers, we're more used to getting involved at the firing end of things, but today, for a change, we're going to be having a chat about the legal aspects of actually hiring, aren't we, Joanne?
That's the plan for today, and there is some rationale around talking about that. Say about 10 years ago, there was this quite rare but definite phenomena of people who would apply for roles specifically with the aim of bringing a claim, anticipating they were going to be rejected, and with the aim of bringing a discrimination claim if they were unsuccessful. I'm sure that some of those people were motivated by a wish to expose discriminatory employers. Others may have had less noble motives. But in any event, that sort of speculative litigation became much less feasible in the fees era. And it was a recent call from a client saying they've had a complaint raised by an unsuccessful candidate that they were slightly suspicious of, that made me think, perhaps this is something that we're going to see happening again.
Interesting, and it is discrimination claims that are the main risk here, really. I don't think there's much confusion about the law here. We know that we can't take protected characteristics into account as part of recruitment, but it's about scrutinising your process and saying, well, prejudice might come in here, or even an appearance of prejudice, and what can we do about it?
Absolutely. There is an ECHR code on recruitment, and that's a good starting point, particularly perhaps for more junior HR practitioners. It sets out things like how job descriptions and person specifications can help you avoid discrimination, and gives some good tips on writing them. It also has quite a good section on constructing application forms and interview questions. Going a little bit deeper than that, there's a whole load of interesting stuff out there at the moment about unconscious bias. I'm sure many of the people watching will be familiar with some of that work. And clearly, if you're in a situation where you can neutralise some of your recruitment information, so if you can take names off CVs, for example, and you can do that at an initial screening stage, then that's got benefits. That's something that's happening more and more in very large recruitment exercises.
Yeah, and you might be able to remove references to race and possibly gender, but age is always going to be apparent to a greater or lesser degree.
Yeah.
Then there are going to be more nuanced issues, and sometimes you can tell from a CV that a woman has taken time out to have children.
Well, that's true if you go looking for it. I suppose the argument is that steps like this mean a candidate's personal characteristics aren't going to be the first thing that jump out at you when you look at a CV. So whoever is selecting forms a view about professional suitability first, and then it's harder for that to be dislodged than it is to allow an unconscious prejudice to stop you from giving that person proper credit in the first place.
Yeah. Well, we're obviously talking about quite a detailed, paper-heavy recruitment exercise here, and I think it's at this point worth deviating slightly to think a bit about all that paper and ultimately what happens to it.
Yeah, well, every recruitment exercise is going to generate data, isn't it? And even a sign in a shop window saying help wanted, from that through to a graduate recruitment scheme with perhaps thousands, tens of thousands of applicants, through to a much narrower but very detailed headhunt for a CEO. You're going to get different data in each case, but it's still going to be there.
And even in that most basic example, the shop will have names and phone numbers of people who've shown an interest, so it's very likely that some people will drop a CV in, and there may be notes taken of informal conversations as well as of interviews if they get that far.
Yeah, so does the GDPR have any impact on how employers should handle recruitment data?
Well, where doesn't the GDPR have some impact? As in many areas, it serves as a reminder of what you should already be doing rather than being a game changer. There's probably a more specific need to directly inform candidates that you will be processing their data and the details around that. And after the exercise, there is a balance to be struck for unsuccessful applicants between retaining data and securely destroying it.
Yes, because there is that possibility of claims that we've just been talking about, it would be a mistake to think that you should simply shred everything once you've got your new starter in place and you know that you're happy with them.
Yeah, that's right, and I think you do need to hold on to data which would be relevant for a claim. The biggest risk of a statutory employment law claim is within the first 3 months, although it may be up to 6 months before you hear of it, given the sorts of administrative delays in the tribunals that we're seeing. So I think we'd recommend securely storing recruitment data for at least that period, but always making sure it isn't left too long after that. And it's not just the unsuccessful candidates that you have to think about. I think taking some time to decide how much application information from a successful candidate goes on their personnel file, particularly if this is something that's regularly accessed, is something you want to think about. It might be better practice to store some application information along with that for other applicants, and just moving across the bare essentials that are relevant to their ongoing employment.
Thank you. Another issue that tends to come up regularly and is a bit less clear-cut than the other areas of discrimination is recruiting disabled candidates. Perhaps I should even say potentially disabled candidates, because of course you might not know at the recruitment stage whether you are dealing with somebody with a disability or not.
I think so, and it's quite helpful to say something briefly about the do's and don'ts of recruiting in that situation. And the first point, of course, is to think about the duty to make reasonable adjustments to the application process itself to accommodate disabled candidates.
That's right, and that's a duty that can be quite far-reaching. For example, there was a relatively recent case in the last couple of years against the civil service. The claimant there was called Brooke, and it was held in that case that they should have altered the methodology of an online selection test so that it would allow an autistic candidate to give short narrative answers rather than selecting a multiple choice option. The whole case is quite a fascinating read, but it's a really good example of where adjustments can potentially go well beyond the sort of usual thing that might spring to mind.
Yeah, so coming back to the practicalities of the process, it's pretty well established that you should be asking candidates whether they require adjustments to the recruitment process due to a disability.
But it is equally clear that that is exactly where you stop.
And since 2010 and the Equality Act, it's been unlawful to ask candidates questions about their health before offering employment, and that includes asking questions of a previous employer, for example, about their sickness absence record, and includes asking them whether they have a disability.
Yeah, and asking those questions, whilst not technically discrimination in itself, can lead to employers who make recruitment decisions based on the answers facing very powerful discrimination claims.
Yeah, that's right, and the burden of proof to show that you chose not to recruit for an innocent reason will be on you as the employer, having overstepped the line in the questions you asked.
Absolutely. Once you get past that selection stage, it is lawful to make a job offer subject to a medical, and there might be good reasons for doing that. Of course, the issue here is that if a candidate is unsuccessful at that point, then the onus is squarely on the employer to show whether they can defend the decision to withdraw. There isn't any way in that situation that you can hide behind an argument saying that, oh, it was actually another reason that they weren't successful.
Yeah, and this change in legislation was brought in because of evidence that disabled people were often being screened out of recruitment processes, particularly where there's a mental health issue. And I don't believe there's been any up-to-date research as to whether the changes have boosted successful applications from those groups of people, but one can certainly see why it might be expected to do so.
Yeah, well, this has been a very brief tour of recruitment. We've not mentioned references, inductions, when you might want to withdraw an offer, lots of other talking points. Maybe we will store those up.
I think so. Thank you, Joanne. In the meantime, if you'd like to discuss any issues to do with recruitment or any of the other points that we've talked about in this tea break, please do contact us. We hope you'll enjoy this one and another one again in a few weeks' time. Thank you.